So welcome back, everyone, to another Canaman GCS podcast. And in this episode, we're going to be interviewing the wonderful Samuel Judge, European patent attorney and partner at PWF, PageWhite Farrer. So we're going to be talking today about the key fundamentals of IP protection and how it relates to the cannabis industry for businesses that are just really starting up in this sector. What factors do they need to consider? And also for companies that are already established, how can they be better protecting their intellectual property and rights? And so thank you very much, Sam, for kindly coming on to walk us through all of this. And you've very kindly helped myself and GCS navigate some of this tricky intellectual property conversation. So maybe as a little starter intro, perhaps you wouldn't mind introducing yourself, Sam, and letting the people know who you are, the wonderful work that you do, and how everything goes on and what happens at PWF as well.
Oh, yeah. So, I'll just start off by saying thanks very much, Chris, for inviting me to today's podcast. This is a really exciting thing to do as a patent attorney, where most of the time we are studying detailed technical documents and not being recorded speaking to I'm sure a fantastic audience. So yes, my name is Sam Judge, patent attorney and partner at PageWhite Farrer. My background is in chemistry originally. I then did a couple of years in the pharmaceutical industry as an analytical chemist, supporting drug development. And I joined the profession in 2012, and then I completed my training, and here I am today. So the technical fields that I cover at the moment are across all types of different chemistry. What I really love about being a patent attorney is getting to learn about loads of different technologies, all across chemistry in general. So I've done some work with pharmaceuticals, agrochemistry, and food production as well. So I hope that I would have the right skill set to support people who are working on cannabinoids. I have done a small handful of cases in this area before, and they have been really interesting. So I'm keen to learn more about the industry and to provide as much support as I can.
Well, thank you, Sam, and thank you for taking the time to walk everyone through the rabbit hole that is law first of all, and then IP, and then thirdly applying cannabis to all of that as well, which is a game in itself. So thank you, Sam. I think maybe perhaps the best place to start is to understand from you what the value of IP is really and why IP matters, because I think a lot of people throw the term around IP, but perhaps don't understand the value of intellectual property to their business, and also again the value of protecting that and knowing very clearly what is yours versus what is, say, public information too. So what would you say, to the layman who's got no legal background whatsoever, how do you sort of define that, and what in your eyes is the most valuable piece of IP in the business jigsaw? And yeah, why is it important, Sam?
So the value of IP to businesses, particularly if you're a startup, you're not going out there thinking that you're going to enforce rights and take people to court. That's not how it really works in reality. It's very, very rare to have to litigate anything. What IP gives you is exclusivity over your ideas. So my area is patents, so I protect inventions. What a patent gives you is the exclusive right to commercialize your invention. And what that means is, after you've invested all of your R&D efforts to develop some kind of product or process, it means that you can get a return on your investment. It's not going to be copied as soon as the product goes onto the market. You have the right to, you have a monopoly over it, and that can be extremely valuable, particularly if you are a startup just entering the market. From discussions with investors at conferences and with contacts, the two things that an investor will look for, first of all, is the team. Who's working on who are they working with, and they will also be looking at the IP. So are the ideas that the team have generated being protected? And there is some very long and not all that interesting to read research from the European Patent Office that shows, as you might expect, that small businesses that have got exclusivity over their inventions are more successful than those that don't. So what a patent is it's a way to seek investment, and to show to potential investors that you're serious, and you've taken steps to protect your business. IP is not just limited to patents. There are other ways to protect your brand and your idea. The relevant ones might be the trademarks. So, for example, you may well have trademarked your logo for GCS. And also relevant to our audience today might be plant variety rights, which is sort of a patent-like protection for a plant variety that's been produced by breeding and crossing different plants. So really, we try to take a bespoke approach. We look at what the business model for what your business model is, and then we will try to find the appropriate types of IP that will support that and that will best help you to get investment and to support and strengthen your position. So we're all about trying to make your business stronger, and yeah.
Boom. Slight dramatic pause there, Sam. In the case then of the cannabis industry, Sam, would you be able to give a few examples of areas where IP and some of that brand protection might be relevant to, say, cannabis companies, CB companies, and maybe cannabis ventures too? Because it is quite what I've found out and realized is that IP is quite a big umbrella too, isn't it? That
Yes,
isn't just, say, a formulation, but as you say, it could be brands, could be trade secrets, for example. So what, in your mind, should a new cannabis venture be looking at, and how could they maybe capitalize more on intellectual property if they're not already?
Okay. So the most important thing is to keep any inventions. So that might be new formulations or new uses that you've discovered of a particular extract or compound. The first step is to keep that secret, because as soon as you disclose what the invention is, so that might be publishing details or presenting at a conference or selling the product. Once you've done that, you make getting protection for your invention very, very difficult in the UK or Europe. There are some grace periods out in the US that people don't like to use because they're very complicated and expensive. But the very first step is to keep your inventions confidential, and then the things that you can protect include, for example, formulations, pharmaceutical uses, but really anything that where you are solving some kind of technical problem might potentially be patentable. So any new product or method that is solving a technical problem could potentially be protected with a patent. For other types of business, for example, if you are marketing CBD for a known use and the value to your business is all in the branding, then you will be looking perhaps more towards trademarks or even registered designs, which you could use to, for example, protect the shape of packaging. So that's a very wide-ranging question. It really depends on what the business is. Once we know what the business is, we can then work out a way to protect it in the most effective way that we can. But on the patent side, vitally important to keep it secret until your patent application is on file. Because if once the cat's out of the bag, that's it. You've had it.
We were talking before, Sam, about some of the plant science as well that this maybe covers, in addition to, say, products and maybe drug formulations or medicines or branding. What would you say that it's a similar process for both sides, whether it be, say, plant science and, say, human biological science or branded products? Is there anything that people need to consider if they are on either end of that spectrum, or is it a sort of similar brush for brands and businesses and products as it is, say, for plant sciences and agrotech?
So you can, for example, protect a new use of a plant extract. Just as an example, you can protect biotechnological methods for engineering plants within the field of patents. You can protect, as I mentioned briefly earlier, you can even protect a plant variety that's produced by a purely biological process. So the fact that an invention involves a plant doesn't make it any less of an invention.
Okay.
And there are certainly ways to protect plant derived innovations.
I would say that is a big chunk of the cannabis industry, is trying to differentiate yourself as a cultivation company, for example. What processes do we use? How do we make ourselves unique or more efficient? Or how are we creating unique and adaptive products, perhaps, too? So in that case then, Sam, I was wondering if you'd be able to give us a little overview of the different types of IP, primarily, say, around, say, trademarks, patents, trade secrets, copyrights. What are those, and what are the sort of different uses or applications for those? I think everyone's maybe heard of those terms, but maybe an example of what those are would also be useful for would-be entrepreneurs, businesses, and cannabis adventurers. Could you demystify some of that for us?
Yes, I'm happy to. So really, a trade secret is your confidential in-house information and know-how which might be a product that's still in development, or an internal process that's still in development, or it could even be your client list. So it can be things that aren't necessary. Unlike a patent, it can protect things that aren't necessarily technical. And there is value in keeping things secret and not disclosing them, even if you don't move ahead to a patent. So you wouldn't necessarily want to publish all of your internal processes online, because someone's going to come along and copy them. So to protect trade secrets, really, you'd be looking at non-disclosure agreements with any partners who you're working with, and making sure that your employees are aware that they are working on confidential materials and that they shouldn't disclose that to the public. So really, any technical innovation, any invention that you're making is going to start off as a trade secret before you decide to make the investment to turn it into a patent. What a patent is really is it's a bargain between an inventor between the owner of an invention, and the state. So this gives you, what a patent gives you is a time limited monopoly over an invention, which lasts for up to 20 years, in exchange for having a patent application published that provides details of how you work the invention. So a patent can protect any sort of improvement that solves a technical problem, as long as it's novel. Novel means it's never been disclosed before the patent application was filed, and inventive. So inventive means that it's not obvious. So there's some kind of unexpected improvement, for example. So a common types of non-obvious inventions might be finding a new use of a particular compound or plant extract, or finding a new formulation that provides a beneficial effect. So it delivers the active more effectively, or it might be a new, it could even be a new agro processing method that gives you an improved yield through some means. So lighting systems, hydroponics, that I've seen cases in that sort of area as well. And then I think you mentioned also trademarks. So trademarks are a little bit different, where you don't have to keep your brand name secret, but you can. So a trademark, it protects a badge of origin. So you can protect your logo, your brand name, and various other things. Thinking back to the dim and distant past, where I studied trademarks a tiny bit for foundation exams, I think somebody protected the color orange that used to be on the telecoms company back when orange existed. They protected that particular color, I think. So you can get a bit creative with trademarks. Trademarks not really my main area of expertise, but I do have colleagues who are specialists in that area. The other another form of IP is copyright, which exists automatically. You don't have to do anything to register it, and it means that somebody can't, for example, copy your training materials and republish them without your permission, and that right exists automatically. And we also have design rights, which protect shape and appearance of a product. And then there are some more specialized types of IP, like plant breeders' rights, also called plant variety rights, which are a little bit like a patent, but they're for a strain of plant that's been produced by a biological way. There are also database rights and various other various other types of IP. So, long story short, regardless of what the business is, we can find something to add value to your company. We can find something we can register as an IP right. So then you have an asset that is transferable, licensable, and you can use that as a way to build your business.
Brilliant. So maybe converse to that then, Sam. As we've gone through some of the practicalities there, what happens when it all goes wrong? And I think that's what people want. Maybe that's probably going to be the biggest motivator for some people. Is like, well,
yeah,
how can this bite me in the bottom? Have you got any examples of where you've seen absolute carnage, and this is all people have done the opposite of IP protection? They've maybe released it, lost it all, and maybe being burnt in the process.
Yes, I've seen that. I've seen things like this happen a few times. The most common problem by far, and that makes it practically impossible to protect the invention, is disclosing it before you file your patent application. I have worked, or I have had sessions with startups who have approached me with really impressive bits of technology, just backed up by absolutely fantastic research. And so we'll have a bit of a chat like this today, and I'll be starting to get excited on, oh, we could cover this, we could cover that, and then they'll say to me, oh, there's a PDF on my website that discloses all the details, and that is just such a feel bad moment, because then any chance of getting patent protection in the UK and Europe is lost, and your only option then is to look at places that have got grace periods, like the United States, where it's quite expensive to get the ball rolling, and you end up with suboptimal protection even where the grace period exists, because the invention has been disclosed too early. That's by far the most common problem that I've seen, the most common mistake, and it is completely understandable, because if you've made something that you're excited about and you want to build your business around, the instinct is to want to talk about it, but unfortunately talking about it is completely the wrong thing to do. You've got to keep it confidential. And the other mistake that I've seen, and this is from chatting to people at conferences, is being too pessimistic and underestimating what it is, underestimating things that you can protect. Patentability only requires an inventive step, and that's so you don't have to send a rocket to the moon. You just need a fairly small incremental improvement. The most common false assumption that I have encountered is people thinking that because the components that they're using aren't new and that have been known for donkey's years, they've brought them together and they've produced an unexpected effect, but they've assumed that they haven't made an invention just because the components were known, and that's not right. You can protect formulations, new combinations, new optimizations. It just means that you need some experimental data to back up the existence of that effect. More things are patentable than you might think.
Yeah,
but you have to keep them secret.
Yeah. Two caveats there that the cannabis industry doesn't make such a good job of, Sam. Typically underestimate what is potentially new or groundbreaking, then on the flip side, tell everyone everything they're doing and then give it all away anyway. I know a lot of scientists are guilty of that, particularly because they want people to maybe like help them develop it or something like that. So I can understand the mindset of how some of those mistakes transpire.
And collaborating with people to develop products is still possible. You just have to make sure that you have a non-disclosure agreement, so that they know not to disclose it, and to lay down in writing who is going to own the invention that's generated from the collaboration. So whether that's joint ownership or whether they're agreeing to transfer their rights to you under some kind of contract. It's only disclosures out to the public, so that's online conferences, journal publications, that sort of thing, that remove novelty. Confidential disclosures don't count, as long as you so you can have a bubble of confidentiality where you have a group of collaborators. They can chat to each other, exchange ideas, as long as everybody knows to keep it secret, keep it within that closed group.
Yeah,
that's okay. It's just not letting it out into the wide world. That's a bad idea. And I think the thing is to maybe to take advice earlier than you think about IP, and to just keep in mind that you might be generating some IP.
Yeah.
For example, I'm quite happy when people give me a quick phone call and ask, should we think about protecting this? Sorry, can we cut that, because that was
yeah, of course.
Yeah. Thank you.
On that note then, Sam, maybe what would be good to run through next is a bit of a process or steps that companies should take if they do suspect that they are maybe sitting on some IP, or they've got something that they would like to commercialize. Should we start writing it down? Do we start doing dictaphones? Do we need data? What are some of the steps that owners, companies, and inventors can take to, I guess, start compiling some of that evidence, but then also start to either document or ring fence maybe what they would consider their IP? Is there a set of guidelines or a set of steps that people should follow?
So the most important thing is to keep everything confidential. Historically, there was a need to document exactly when you put the invention into practice. That's under some old US law that changed back in I think it was 2013 with the America Invents Act. It used to be possible to, they used to call it swearing behind, where if you came along with your lab book and it was before somebody else's US patent, you could say, oh no, actually we made this first. That is not so critical nowadays because of there's been a change to the law, although of course it is always useful to keep a lab book and record what you're doing. So initially, so how the story goes is, initially you want to keep the things that you're working on confidential. The time to start thinking about filing a patent application is where you have achieved some kind of surprising result or improvement, and you think that is worth investing in and worth commercializing, and at that stage you may only have some preliminary data, early phase data. I'm thinking here about chemical inventions, and that's good enough. Early phase data is fine for a patent application. It doesn't have to be journal standard data. And then what we would, and then that's probably the time to come to us as patent attorneys, when you know what the invention is, and if you're working with something chemical, you've got a bit of early stage data, and then we can prepare an application for you. What the application drafting process looks like is we'll ask for the data, which you can give to us in any kind of format. We'll have a meeting to discuss what the invention is, and then we go away and write it up, and we come back to you with a draft. So once the data collection is done, it's a fairly straightforward process. Some relevant considerations for the data collection part might be that the patent system works on comparisons. So we're always, the patent office will do some searching. They'll identify some what we call prior art, so something that's been done before, and we want to make some kind of comparison with the prior art to show that we've achieved something.
Okay.
So if in your testing you've done a comparison with an earlier product or a competitor's product, having that comparison is really useful. Also, often where we're looking at mapping out optimized ranges, even the results of the experiments that don't work can be quite helpful, because that lets us draw a line in the sand and say, okay, if this parameter is above X, the invention works. If it's below X, then it doesn't. So we should set the limit on the scope of our patent at X. And that's, but all of this is it changes a bit it changes quite significantly on a case-by-case basis, depending on what the invention is. And we can work with the inventors to say what we need in a particular case. Really, what you're looking for patentability is something new, solving a problem, and has been kept confidential.
That's like the three pillars almost of a patent. What's the timeline like for processes like that as well, Sam? Like, how is it? Years? Is it months? Is it weeks? What are the sort of timelines that people should expect if they do want to go down this path?
So for getting to a state where you're able to start disclosing the invention, so that means putting an application on file, that can be done in 3 days.
Okay.
But that's
Theoretically.
Theoretically, if you know your patent attorney already and you're happy that you get what you get, but for a first time applicant, I would say leave it about 6 weeks, a month. 6 weeks that's a fairly good length of time to really get to the bottom of the invention, draft up the application, and give you a chance to review. So getting the application on file is relatively quick. Once the application's on file, you can then disclose the invention, you can sell your product, you can market it, no bother. It's not going to hurt your patent, it's not going to hurt your application. The timeline for getting granted rights is quite a lot longer. That will take realistically 3 to 5 years or longer in some cases. So getting through to grant is quite a long, drawn out process. Getting an application on file so your business can get moving pretty quick.
Dare I ask about potential costs as well, Sam, with regards to, particularly if you're looking at investors and investing further in a new piece of IP, what should people maybe be wary of in terms of working out as well? Is it cost effective? Is it is it a priority piece of IP? Are there other things to tackle? What would maybe be some of the considerations around that?
So the difficulty with the patent system that is really quite, I don't like it because it's hostile to startups and new applicants, is that the costs are quite front loaded. The reason for that is that your patent application, which is a complex legal document, it has to be as correct and complete as possible when you file it, because the ability to add material later is extremely limited.
Okay.
Extremely limited, and requires jumping through some procedural hoops that have got tight deadlines on them. But let's not worry about the procedural complexity. The costs are at least predictable because there is a defined time frame. The costly parts are starting the process off at month 0, and then filing any applications overseas at month 12. And there are mechanisms that you can use to buy a bit more time for filing overseas. So the costs are quite front loaded, but they are predictable. If a company comes to us, we can give cost projections that cover the first 2.5 years, and we can do that quite reliably. We would also always agree a budget up front before we put pen to paper.
Yeah.
We find that because filing a patent application is quite a big investment, it's not something necessarily to do lightly, unless you're a very big company and trying to build a thicket of overlapping patents.
Yeah.
But if it's a key piece of technology that you're building your entire business around, that is something worth protecting. It lets you show to investors that you have exclusivity, and then later down the road, it gives you the option to license the technology out to another company. For example, if you don't have the manufacturing capacity in-house, or if you want to license out to a foreign country who are a bit further down the road towards legalization, like Canada or certain parts of the US, you could, for example, partner up with a Canadian company. If you hold a Canadian patent that you can get based on your UK patent, if you jump through some procedural steps, you can have them produce and commercialize it out there, and you can collect the licensing revenue. So it's a powerful tool. A patent is a powerful tool, but it is, because it's such a powerful tool, the costs are unfortunately quite high, and what we can do to support you is to give some certainty over when the cost will be incurred, and estimates that we will stick to.
Yeah. So it sounds like it should be something valuable, unique, and rare in order for it to be. I think there's a lot of people that overestimate how much IP they maybe do have as well, and what would actually be worth patenting or maybe trademarking or copywriting. So I guess that's quite an insightful little introduction there, Sam. You mentioned internationally as well, say America versus the UK. What are some of the regional variations that should maybe be considered as well? What are the perimeters and boundaries, I suppose, of your IP? Is it if you patent in the UK, that covers you just for the UK, or does it give you
that's right? So patents at least are territorial. So that means you only get protection in the places that where you file a patent application. There are some international organizations that let you pursue a patent in multiple countries simultaneously. So in Europe, we have the European Patent Office, which will cover whole of the EU plus the UK, Switzerland, Norway, various others. And there are other organizations. So there are a couple of African organizations that cover regions in Africa. But as a general rule, patents are territorial, and you need a patent application in the territory where you want your protection. Trademarks, again, are territory. The trademarks will be territorial as well. For copyright is a little bit outside my specific areas of expertise, but it is an automatic right, at least in the UK, and I think in many places they will recognize the copyright, but I can't really speak about that with certainty.
No, thank you, Sam. Maybe a couple of final questions and thoughts then, Sam.
Yeah.
In your experience, and I guess maybe to reorientate people on some of the benefits, values, and upside potential of IP protection, what cases or examples maybe have you seen where that has really paid off? So I'm sure those are probably intellectual property is quite rare in itself anyway, but I guess cases where that IP has been a particular success are also quite rare. But where do you see and have you seen the most successful outcomes from people taking the time to get things patented and protected? Are there any cases or examples that you could maybe highlight as examples of when it does go well and it is a success and it really sort of comes to fruition?
Yes, certainly. So I've been working with a small startup company since not long after I joined the profession. So I think I first worked on one of their cases back in 2013. They had done some research about this was all to do with stabilizing biomolecules. And they had fantastic data, and it's really remarkable how well it worked. And they have built their entire business around that piece of technology, and they're still developing it. And they were based on their work. They were involved in some of the response to the pandemic. I'm limited in what I can say on a podcast because of confidentiality obligations, but they made an important contribution, and if they hadn't registered it as IP, because the materials that they were using were off the shelf and they were combining them to get this special effect, if they hadn't have had their IP, then they probably would have been cut out of the loop, and they wouldn't have seen the impact from their invention. So Yes, you can take a piece of IP and you can turn it into a successful business. Other clients that we've worked with, they've developed a product, and then they've sold out the IP for large sums of money. So there are success stories, and patents are just
Yeah.
yeah. Sorry, can we edit that down a bit?
Yeah, of course.
And just keep the first example, because I think I lost track a bit there.
Maybe it's a bit of fuel for a second example, Sam.
Yeah.
Would we be able to use, say, Apple as an example of IP? Perhaps, like, what within Apple would have been patented? What would they have seen value from? Can you think of any sort of like mainstream big companies that people might know where the IP that they've got is maybe OpenAI, for example?
So I've done a bit of work for Microsoft. I could talk about that briefly.
If you're able to, Sam. So I find it so interesting. I don't think many people could then tie that to an example specific case, say a Microsoft or an OpenAI. Do you want to freestyle one of those?
Yeah, I'll give that a go. So working
I can set you up with a
I think if you set me up with a question, and then it might sound a bit more natural.
We'll do that.
Thanks.
I was just having a little mental review there of some of the things you talked about as well. So building on your example there of that small startup, are there any big companies out in the world where they've really capitalized on their intellectual property that you could give as a great example for potentially cannabis businesses to live up to, or try and recreate or mirror the success of?
Sorry. I think my example there doesn't quite land with the Microsoft thing.
That's okay.
Sorry, I need to rethink.
No worries.
Because that was all about that case was all about a quantum computer that they just launched, and I worked on some of the fabrication methods that went into that.
I think that would be a cool example, to be honest, Sam. Everyone's heard of quantum computing, but wouldn't know what the hell. So I think that'd be a good forefront example, to be honest, Sam.
Okay. So I'll just let me refocus. So in private practice, we also work with a lot of very large companies as well. They pursue wide-ranging. They have any large company will have an IP strategy to protect their innovation so that they can't easily be copied. One example that springs to mind is I've done a little bit of work here and there for Microsoft on some of their quantum computing related inventions and how these devices are fabricated, and we saw in the last few weeks that they have put some of these technologies into a quantum computer, and they're now able to show this to the world, knowing that it can't be copied because they have their IP rights in place. So yes, IP is something that is very important in business, generally, to companies of any size.
That's very helpful, Sam, because I think a lot of people, and at sort of this stage in the cannabis industry, everything's very much in its infancy, and a lot of the processes and industry practices are very basic. So it leaves a lot of scope for some of that industrial innovation, but also product innovation. And sort of new ways of working. So I think everyone that's been listening will be probably making a few notes, thinking about, maybe I've not considered this, or maybe that's something that we should ring fence or consider more deeply, perhaps. And I think also what I've maybe inferred from a lot of this as well is like long-term thinking, Sam, and it being a bit, rather than thinking about today and tomorrow, over your next 10 years, going back to the quantum computer example, the development timeline for that, say, versus the average cannabis company, which is just thinking about next week, there's a big separation there in terms of like business quality and the mindset behind those.
For an IP strategy, you need to be thinking a few years ahead. As I've, at the risk of repeating myself once again, I've mentioned the importance of keeping inventions secret, and one of the worst feel bad moments to see is a company who've developed something, they've put it out there, it's succeeded in the market, but because they haven't got any IP on it, someone else has come along and copied it, some much larger company. That's another one of the classic mistakes that I've seen, and something to really avoid. I think the solution is to be aware that IP protection is available, and to pause and think before putting anything out into the market or out into the public domain, because you could be losing something potentially very valuable that could be the basis of your business for the next 10, 15, 20 years.
Yeah. I'd say, as a note to the audience, particularly say scientists and colleagues of mine that are watching this, keep your mouth closed, keep it concealed. And I say keep it concealed, but I think a lot of experts and scientists in their field do end up missing out on a lot of that upside because they have just told everyone about their vision venture project, which again is sort of what science is about, is you want to get people to buy in and exchange ideas and work together. But then in the business world, that isn't necessarily the best practice that will get you to the actual endpoint of you having developed a quantum computer process, for example. So thank you very much, Sam, for walking everyone through some of this minefield, really, or a bit of a labyrinth legally. And I guess, do you have any closing thoughts or comments or pieces of advice for people that have been listening who've maybe got a bit more to think about now than they did? What maybe words of guidance or advice would you give to them to reassure them perhaps that there is it's not as complex as it sounds, and maybe there are services out there, there are people out there as well that know what they're doing?
So I would say that let your patent attorney worry about the procedural complexity. Just keep your invention secret and ask for advice, and we can help you from there. But the really most important thing is to keep the invention secret, because once it's out into the world, my ability to get protection for you is severely limited.
And final question, Sam, and I'd be interested to hear your thoughts on this. I hear a lot of the time that NDAs aren't worth the paper that they're written on. How do you feel about that as a statement?
Yes, that's a controversial one, but to an extent, I think you're right. You don't necessarily need to have an NDA to impose a requirement of confidentiality, and enforcing confidentiality, a breach of confidence through the court, is going to be fantastically expensive and really quite difficult. So you are better off, if you can, getting a registered right, like a patent, for example, because the legal test, first of all, the legal test for patent infringement is a lot simpler than the legal test for breach of confidence. There are fewer factors to think about, and also even massive companies will respect a patent held by a small startup because of the threat of reputational damage if they are being seen to be bullying an individual inventor. So you might actually get to a good outcome where the big company approaches you to say, we'd quite like to buy you out, and to me that sounds like a victory.
Yes. Well, hopefully, Sam, this leads to many new pieces of cannabinoid IP being developed and cannabis companies being a bit more savvy with their intellectual property and brands and trademarks and data and everything else in between. So thank you in advance for that, Sam, and thank you for taking the time to walk people through what on earth IP is, where to start, what to look out for, what the risks are as well. So a big thank you for your kind wisdom, Sam, and for hand-holding me and the community through all of this. And if there is anyone that's got questions, been affected by this, would like to get in touch, have a bit of a discussion, we'll be putting all of the details for Sam, PageWhite, Farah in the description in the community as well. And you should and will be able to and you will be able to connect with Sam via the community as well if you do have questions. And I'm sure Mr. Judge will be able to point you in the right direction and guide you safely to your destination. So a big thank you, Sam. Hugely appreciate it. And I look forward to many more IP conversations with you and trying to make the cannabis industry a safer, smarter, and more scientific ecosystem. So thanks very much, Sam.
And thank you very much.
And looking forward to speaking further. So thank you everyone for listening to this conversation. I hope you found it insightful and as informative as I have. And we look forward to connecting with you and linking up in our next interview podcast. So thank you very much for listening, and we'll see you all very soon.